Now we know that the judicial branch is made up of human beings. And we know that once they put on a black robe, they don't automatically cease to have all opinions and influences and history and personal life experiences. So there's a judicial philosophy for everybody. Some people believe in judicial restraint. Some people believe in judicial activism. Some people believe in strict constructionism. And there are arguments to be made on each side. How should we interpret the Constitution? Strict constructionists would say that judges are bound by the wording of the Constitution, and there's really no interpretation that's necessary. You simply look at the words and strictly construe them. On the other hand, people say that judges should look to the underlying principles of the Constitution. What were they trying to get at here? What were they trying to protect us from? What were they trying to do for all the people? So activist judges would take the underlying principles of the Constitution and apply them in modern day interpretations, and really based on what they think is right. Today we see that most strict constructionists tend to be more conservative, while most activists tend to be more liberal. Although in recent years we've seen the activist label placed on both liberals and conservatives. Those who make an argument for judicial activism would say that the courts are there to correct the injustices of history and of other branches of government or of state governments when those other entities refuse to or are unable to do so. They say that the courts are the last resort for those without power or influence to gain new laws. And so judicial activism is sort of the court of last resort for people who can't get any satisfaction someplace else. Now, others would say that judicial activism is not a good thing because it's not up to the courts to make laws, it's up to the lawmaking bodies to make laws. Not to mention, judges lack expertise in designing and managing complex institutions. So if you're going to have the courts making public policy with a background not in public policy but in law, then you're looking to the wrong people to make decisions. Initiatives require balancing policy priorities and allocating public revenues. An argument against judicial activism is also that what people have to do in government is they have to weigh these priorities, whereas in the judicial branch, they simply are interpreting the laws, and they don't have to weigh these things. Plus, they're not getting reelected, right? Courts are not accountable because judges are not elected. How would you answer this question? A strict constructionist believes in a or an blank constitution. Certainly not living and breathing and changing. Dead? I don't know. Finally, let's think about how the court should change, or if it should change. Should the judicial branch be making policy? Does judicial review give the Supreme Court the ability to make policy? Now, here's an example of where we would say that a more conservative decision is seen as a more activist decision. In Citizens United, public policy was made that changed how the laws related to campaigns were implemented. Policy making. Should the court be overruling itself? Should it change, for example, in Plessy versus Ferguson in 1896, to allow Linda Brown to go to school in her local school in Brown versus Board of Education in 1954? Or should it stick with, right? Should it stick with its original public policy that separate can be equal? Should there be an ability to overrule itself in future decisions? Or should it be more easy to overrule itself in order to right some wrongs? What about implementation as we reform or think about reforming the court? The court doesn't have an enforcement mechanism. And so when you see things like Brown versus Board of Education, when you see Little Rock, Arkansas, when you see Governor Wallace standing in front of the school doors, the court really has to make decisions and wait for the other branches, specifically the executive branch, to enforce those decisions. Should the judicial branch have more ability to implement its decisions? Or does that take the judicial branch and make it way too powerful? Some things to think about going forward. Should there be additional checks or fewer checks on judicial power? Right now, judges have no enforcement mechanisms. That's a check on their power. Confirmation and impeachment proceedings can happen. Happens more for judges to be impeached than any other branch of government, mainly because they're there for life, right? They are not subject to elections. But should there be more? Should there be shorter terms? Should the confirmation process be different? Should there be more judges, more justices? Should the judges who are appointed be given an up or down vote, regardless of who controls the U.S. Senate? Checks on judicial power. Of course, if the judge or justices decide something is unconstitutional, that legislation can be revised. The legislative branch can even amend the Constitution to thwart the activities or the opinions of the judicial branch. Legislative and executive branch can also, and laws can be passed restricting remedies that are given when the law isn't followed. So there's things to think about as we think about the checks on judicial power. Are the checks important? Are they satisfactory? Should there be more? Should there be less? Lots of things to consider as we think about reforming or not the judicial branch of government.